As licensed insolvency trustees, we not only help people and entrepreneurs and their companies with their debt problems and financial challenges, but we also act as the independent, court-appointed estate trustee for deceased estates, where either the person dies without a will, and so there are no named executors, or the named estate trustees need to recuse themselves, either because of a conflict or they do not feel competent enough to do the work. So this Brandon's blog is about what happens to common law partners when one of the partners in Ontario dies. If you're a common law relationship in Ontario, don't assume that you'll automatically inherit when your partner dies if they don't have a will. The case described in Brandon's blog below shows the crucial importance of financial paperwork, clear intent, and legal support. Make sure your plans and your paperwork are ironclad, or you could be left out in the cold. Smith Estate Trustee Ontario can guide you through every twist and turn of your estate dispute or estate planning. My name is Ira Smith, President of Ira Smith Trustee and Receiver Inc. If you have any questions at all, either about this Brandon's blog or anything else, give either Brandon Smith or myself a shout out. Shoot us a message, give us a phone call. We would love to speak with you. I hope you enjoy the rest of this video and find the information helpful.
Welcome to Estate Matters presented by Ira Smith Trustee and Receiver Incorporated and Smith Estate Trustee Ontario, where we break down complex inheritance laws into simple terms. I'm your host, Sarah, and today, we're diving into a shocking Ontario court case that every common law couple needs to hear about. So, Ira, tell us about this Giuseppe Laguna case.
Thanks for having me, Sarah. I'm Ira Smith from Smith Estate Trustee Ontario, and this case should be a wake-up call for thousands of Ontario families.
What happened?
Giuseppe sold his BC home for $342,000 and moved to Ontario to be with his new partner, Ingrid. They lived together, shared finances, and acted like a married couple. But when Giuseppe died in 2021 without a will, his estranged daughter, Amanda, tried to claim the entire $206,000 left in his investment accounts.
Wait, his daughter, whom he hadn't spoken to in years, could just claim everything? What about Ingrid, his partner?
Exactly the problem, Sarah. Ontario law doesn't automatically protect common law partners like it does married spouses. If Giuseppe had been legally married to Ingrid, she had been first to the inheritance under Ontario law. But because they were common law, she had to fight in court to prove Giuseppe wanted her to have the money.
That's terrifying. So what saved Ingrid?
Smart financial planning. Giuseppe had put Ingrid's name on joint investment accounts with rights of survivorship. This meant the money would automatically go to her when he died, bypassing the estate entirely.
But the court still had to decide, right?
Yes, because there's something called presumption of resulting trust. Basically, the law assumes that if you put someone else's name on your account, you didn't really mean to give them the money unless you can prove otherwise.
What kind of proof did they need?
Ingrid brought the bank's financial planner to testify. He confirmed that Giuseppe explicitly understood what joint with rights of survivorship meant and was adamant about wanting everything to go to Ingrid. The judge also looked at their relationship. They lived together, shared expenses, and Giuseppe had already named Ingrid as beneficiary on his retirement accounts.
Meanwhile, his daughter Amanda had
no relationship with her father for years. No communication, no financial support. The court basically said Giuseppe's actions spoke louder than blood relations.
So what's the big lesson here for our listeners?
3 critical takeaways, Sarah. First, common law partners in Ontario have 0 automatic inheritance rights. Second, joint accounts with rights of survivorship can protect your partner, but you need proper documentation and witnesses. Third, don't assume, get a will.
What about other benefits? Like pensions?
Great question. The Canada Pension Plan does recognize common law partners for survivor benefits if you've lived together for at least a year. But workplace pensions and other benefits vary by plan. You need to check every single account and beneficiary designation.
This is overwhelming. Where should people start?
Start with the basics. Update all your beneficiary designations, RRSP, TFSA, life insurance, pension plans. Consider joint accounts for shared assets. But most importantly, write a will. Even a simple will is better than no will.
And if families are already in an inheritance dispute?
Don't go it alone. Estate litigation is complex, and Ontario courts have strict deadlines. Professional estate trustees can help gather evidence, navigate the legal process, and protect your interests.
Any final thoughts?
Giuseppe's case shows that love isn't enough, you need legal protection. Whether you're married or common law, blended families or traditional ones, proper estate planning protects the people you care about.
That's all for today's Estate Matters.
Thanks for having me, Sarah. Remember, don't let uncertainty rob your family of their future.
For more information about independent Ontario estate trustee services, visit probateinontario.com. I'm Sarah. Thanks for listening.